Labor Law of Cambodia, 1997, General Working Conditions, Wage. Chapter 6, General Working Conditions, Section I, Wage, A. Wage Determination, Article 102. For the purposes of this law, the term wage, irrespective of what the determination or the method of calculation is, means the remuneration for the employment or service that is convertible in cash or set by agreement or by the national legislation, and that shall be given to a worker by an employer, by virtue of a written or verbal contract of employment or service, either for work already done or to be done or for services already rendered or to be rendered. Article 103, Wage includes, in particular, actual wage or remuneration, overtime payments, commissions, bonuses and indemnities, profit sharing, gratuities, the value of benefits in kind, family allowance in excess of the legally prescribed amount, holiday pay or compensatory holiday pay, amount of money paid by the employer to the workers during disability and maternity leave. Wage does not include health care, legal family allowance, travel expense, benefits granted exclusively to help the worker do his or her job. B. Guaranteed minimum wage, Article 104. The wage must be at least equal to the guaranteed minimum wage, that is, it must ensure every worker of a decent standard of living compatible with human dignity. Article 105. Any written or verbal agreement that would remunerate the worker at a rate less than the guaranteed minimum wage shall be null and void. Article 106. For work of equal conditions, professional skill and output, the wage shall be equal for all workers subject to this law, regardless of their origin, sex or age. Article 107. 1. The guaranteed minimum wage is established without distinction among professions or jobs. It may vary according to region based on economic factors that determine the standard of living. 2. The minimum wage is set by a PRACA's ministerial order of the Ministry in charge of Labor, after receiving recommendations from the Labor Advisory Committee. The wage is adjusted from time to time in accordance with the evolution of economic conditions and the cost of living. 3. Elements to take into consideration for determining the minimum wage shall include, to the extent possible, a. The needs of workers and their families in relation to the general level of salary in the country, the cost of living, social security allowances, and the comparative standard of living of other social groups. B. Economic factors, including the requirements of economic development, productivity, and the advantages of achieving and maintaining a high level of employment. Article 108. For task work or piecework, whether it is done in the workshop or at home, the wage must be calculated in a manner that permits the worker of mediocre ability working normally to earn, for the same amount of time worked, a wage at least equal to the guaranteed minimum wage as determined for a worker. Article 109. Minimum wages established by virtue of this law must be permanently posted in the workplace and in payment and recruitment offices. Article 110. The employer shall include the commissions or gratuities, if any, when calculating remuneration for paid holiday, dismissal indemnity in the event of dismissal and for damages in the event of termination of the labor contract without prior notice, or for an abusive breach of the labor contract. The calculation is based on the average monthly commissions or gratuities previously received over a period not to exceed the 12 months of service up to the date of leave or termination of work. Article 111. The specifications for a labor contract of government services or of public institutions shall include all necessary stipulations to ensure the enforcement of the provisions of this law pertaining to the guaranteed minimum wage and general work regulations. Article 112. The employer must take measures to inform workers in a precise and easily comprehensible fashion of a. The terms regarding wage that apply to the workers before they are assigned to a job or at any time that these terms change. B. The items that make up their wage for every pay period when there is a change to the items. C. Payment of wages. Article 113. The wage must be paid directly to the worker concerned, unless the worker agrees to get paid through other methods. The wage shall be paid in coin or banknote, which is legally circulating, notwithstanding provisions to the contrary. Article 114. The employer, however, is prohibited from restricting the worker's freedom to using his wage at his disposal. Article 115. Except for acts of God, wages shall be paid at the workplace or in the employer's office if it is nearby. The payment of wages in the form of alcohol or harmful drugs shall not be allowed. Article 116. Laborers' wages shall be paid at least 2 times per month, at a maximum of 16-day intervals. Employees' wages must be paid at least once per month. Commissions due to sale agents or commercial representatives must be paid at least every 3 months. For all task work or piecework that is to be executed for longer than 15 days. The dates of payment can be fixed by agreement, but the laborer must receive partial payments every 15 days and be paid in full in the week following the delivery of the work. In the event of termination of a labor contract, wage and indemnity of any kind must be paid within 48 hours following the date of termination of work. Article 117. In case of an unjustified delay in the payment of wages, the labor inspector shall serve notice on the employer to pay the wage of his workers by setting the deadline by which payment must be made. If payment is not made by the deadline, the labor inspector shall write up a report and bring the matter, at no cost, before the competent court that may take any measure to keep the asset in the interest of the workers, including appointing a provisional administrator as well. The labor inspector can then take any actions to force the employer to fulfill his obligations toward his workers and employees. Article 118. In the event of disputes over the payment of wages, the employer has the duty to prove that he has made the payment. This proof can be derived from the signature of the worker concerned or those of 2 witnesses if he is illiterate. Put in the payroll ledger that the employer is required to keep. Article 119. It is not contradictory to the worker for the confirmation that all wages and remuneration are already paid, or for any other similar term of confirmation indicating that the worker has renounced all or part of his rights in the contract, either during the execution or after the termination of the labor contract. Even though the worker accepts payment without protest, this does not mean that he has renounced the right to payment of all or part of his wages, allowances, or other benefits granted him by legislative, regulatory, or contractual provisions.